Hi everybody, it is October 24th, 2023. I appreciate you watching today. If you are enjoying the content, I would ask that you consider subscribing to the channel. Please spread the word, share the videos with your friends, and hit the like button, please. I was going to be doing an interview on Jeremiah Babe's channel today. That has been postponed. We were going to get a little range time in today, do some training, but one of our range vehicles had a little bit of problems this morning early on, so we're going to have to table that until later in the week or next week. But I look forward to doing that with Jeremiah over at his channel. So I saw an article this morning that I thought was appropriate. I'm going to tie it into the title of the show, which is "Realtors Are Not Lawyers." And the article is entitled "More Home Buyers Back Out of Contracts Over Affordability Concerns." And it says, according to a new report from real estate company Redfin, more than 16% of transactions nationwide last month were canceled as buyers are being extra careful in this increasingly unaffordable market. It says pending sales ticked up and closed sales ticked down can be explained partly by a high portion of buyers backing out of contracts due to rising mortgage rates, the report stated. It says roughly 53,000 U.S. home purchase agreements were canceled in September. That equals to 16.3% of homes that went under contract that month. And that's the highest percentage since October of 2022, the article says, when mortgage rates surpassed 7% for the first time in 2 decades. And we know now that mortgage rates have surpassed 8%. Experts say if buyers feel like they're not getting a good deal, they're walking away. That article it's very telling, number one. Number two, I think it could be a bit misleading. Obviously, the rules and laws vary from state to state and jurisdiction to jurisdiction, so you have to make sure you seek counsel in your own local area under your own local laws. But the reality is, it's not always that easy to just simply walk away from a real estate contract, meaning contracts that are signed are usually, with exceptions, they're meant to be enforced, they're binding agreements, and in the absence of some extenuating circumstances, courts will enforce contracts. So, as they're written. So keep this in mind, especially if you are a buyer. When you have your realtor put together an offer as a buyer, the realtor is in essence drafting that contract. Now, I know in many jurisdictions, including California, they're using these form type contracts. In California, they are the California Association of Realtor, or CAR forms, that the realtors are often using, but they're still preparing a contract, albeit they're checking boxes and filling in some material terms. But where things sometimes get a little bit hairy is when the contract is modified. There are several counteroffers back and forth. There are amendments to the contract. There are addenda to the contract. And what happens then is the realtors start acting as the drafters of legal documents. And you got to keep in mind that realtors are not attorneys. Now look, many of my good friends are realtors. I am not bashing realtors. They are absolutely necessary to these transactions. But again, realtors have their role in the transaction, just like the mortgage company does, just like the lender does, just like the title company does. And I'll repeat again, oftentimes there is, or at least there should be, a role for a real estate attorney in these transactions when parties start drafting those additional type documents. The point being is that they need to be prepared in such a way that the ambiguities are minimized, or I would say eliminated, but to the extent they can be, minimized substantially, because if ever a dispute ever arises, the courts are going to be, or a judge in a black robe is going to be asked to weigh in on what was the intention of the parties. And everyone's going to have their own perspective on what those intentions were. And the more that you can refer back to a clear and concise contract, again, including an amendment or an addendum or a counteroffer, those all become parts of the integrated agreement. So, for example, let's talk about cancellation if you're a buyer. Again, in California, you normally have what's called a due diligence period of time to conduct your inspections, to review the title report, to conduct a survey, or to review homeowners association documents. Anything that you need to do to determine the suitability of the property for you needs to be done within that contingency period. And once that period expires, or that contingency gets withdrawn, then it becomes more difficult to simply cancel a contract if you're a buyer. Now, a lot of times you'll have a loan contingency that will be enforced until the close of the deal. And if the loan doesn't come through, then that a lot of times will give you the rights to terminate the agreement. Again, it all depends on your specific contract, your specific circumstances, and the state that you are residing in. But it is not always just, well, if it turns out that towards the close of escrow, it's going to be too big of a payment, we've changed our mind, we're going to walk away from this deal. It's not always that easy, folks. And what you usually have done in a purchase contract as a buyer is you put down what's called an earnest money deposit. And that deposit stays in escrow. In California, it's not to exceed 3% of the purchase price, but depending on the price of the home, that can be a substantial amount of money. What happens if the buyer determines they want to back out of the contract? Well, if it's for a proper purpose and if it's within the contingency period, usually that's not going to be a problem. But if it's after that period, or if the seller takes issue with the reason upon which the buyer is trying to back out, and there's no clear contingency remaining in place or clear avenue for the buyer to cancel, the seller may object to that. And what happens is then the seller says, well, I'm not going to agree that your earnest money deposit can be returned out of escrow. And then what happens is the parties have a dispute over that chunk of money, whether it's $10,000, $20,000. I've seen deposits much higher than that. And it becomes a substantial amount of money, especially if you're a buyer who's looking to take that deposit and go and search for a different house, maybe a little less expensive house, or a house in a different area. It's unlikely you'll have two deposit amounts readily available to you to do that. Again, there's exceptions, but keep that in mind. If your money's tied up in escrow number one, how are you going to open escrow number two on a different property? So it can really put a monkey wrench in your plans. It can become very stressful, very time consuming. And I will tell you this, I oftentimes get involved in escrow deposit, earnest money deposit disputes between parties. And usually it is when the buyer wants to back out and the seller is refusing to release the deposit. And the seller then uses that as a negotiating tool to say, well, I've been inconvenienced and therefore I'll return to you maybe a portion of your deposit. Or in some instances, the seller will say, I'm not going to agree to return any of your deposit because I believe you as the buyer are in breach of the contract. So keep these things in mind, because it seems to me that where we're heading with this economy and with the housing prices continuing to be high, but more importantly, mortgage rates being high and all the uncertainty that buyers now are facing, this is going to become a bigger issue where buyers are looking to cancel. The next item I'll touch on, it's probably a subject for an additional video, is the idea of arbitration. And in California, there's a section, these CAR forms, these purchase contract forms that realtors often use regarding binding arbitration. And look, as a matter of course, realtors just tell their clients just to initial those provisions. If the binding arbitration provisions are not initialed by both parties in California, then any dispute does not need to be resolved by binding arbitration. But as a matter of routine, the seller's agent says, "Oh, just initial that." The buyer's agent tells their client to initial, and you have a fully initialed binding arbitration provision. What does that mean? That means if a dispute arises over the contract, the parties have agreed to submit that dispute to a binding arbitration before an arbitrator. You're no longer entitled to file a case in a regular courthouse. You waive your right to a jury of your peers to decide the issue. You waive the right for a judge to decide the issue. And I will tell you this, in California especially, I'm speaking locally, there are, with very few exceptions, there are absolutely or almost no rights to appeal the decision of an arbitrator. Realtors will always say, and sometimes lawyers will say, well, arbitrations are a much quicker process for resolving a dispute. In some situations, that's absolutely correct. An arbitration usually proceeds from beginning or inception to conclusion to an award quicker than a regular court case would. But not always the case, and what you're giving up may not be what you're getting in return in terms of benefits. I'll also tell you this, arbitrators are paid by the hour. When you file a case in a regular court, you pay a filing fee, you pay motion fees along the way. When you get to trial, if you're going to have a jury, you post your jury fees, and you pay a court reporter to be sitting there every day creating a transcript. So if you don't like the result, you can appeal it, take it to the appellate court. In arbitration, so those costs in a court case are relatively capped, and you're not paying the judge to be there or the jury to be there hourly per se. In an arbitration, you are. And I will tell you, in my experience with arbitrators, most of them are highly qualified, but their hourly fees are commensurate with their qualifications. And the fees that arbitrators are paid, they are paid by the hour for everything they do in the case, whether they're listening to motions, whether they're making rulings, they're discussing discovery with you, there's conference calls, and of course then there's the arbitration. If you get into a lengthy arbitration over a real estate contract dispute that takes numerous days, the fees that you have to pay an arbitrator can be very, very, very extensive. So that's something that you should also keep in mind and do your research before you just that's a wrong, I don't use the word arbitrarily, but before you just as a before you take your realtor's instruction, just initial a provision like that, it would make some sense to seek a qualified attorney to explain that provision to you. Again, I wouldn't seek legal advice from your realtor. They're not lawyers. Sure, there are exceptions where a realtor is a lawyer. I know many more lawyers that are realtors as well, but just keep that in mind for your own protection. I had a case talking about the no rights to appeal. I had a big arbitration years ago, and it was over a massive real estate building dispute between land developers, and there was some hard money loans involved, and the project went south, and this ended up in court. One party sought to compel the matter to binding arbitration, and we went through a multi-day arbitration. My client had what I thought was a dead to rights successful usury claim that the interest rate being charged on the notes exceeded that by law, and therefore it was an unenforceable note. And we presented a whole lot of evidence and a whole lot of what I thought was compelling case authorities and statutory authorities on the point. At the end of the day, the arbitrator did not find in my client's favor and upheld the notes. And I will say it was a seven-figure dispute. And the point is that we believe that the arbitrator in that case made a wrong decision, but there was nothing we could do because the parties had years earlier agreed to a binding arbitration provision in their contract. We had no rights to appeal this arbitrator to have it looked at by a fresh pair of eyes to determine if in fact the arbitrator made a correct decision or incorrect decision. Am I saying that in all circumstances, binding arbitration doesn't make sense? No. Am I telling you never to initial arbitration provisions? No. I'm telling you to seek the advice of counsel in your own state, your own jurisdiction, but it is something worth considering before you just willy-nilly sign or initial these arbitration provisions. And again, relative to canceling the contract, backing out, you can't just show up one day and say, I've changed my mind. There are a lot of nuances and issues that come into play depending on where you're at in the process of the real estate transaction. Hope this has been helpful for you guys. Of course, please get your 30 minutes of your exercise in today, get some walking in, get your steps in, hit some push-ups, hit some sit-ups today, grab that water, stay hydrated. We need to be physically fit as a populace to deal with everyday stress, which is increasing more and more with all of the events and conflagrations that we're seeing right now. With that being said, I hope you all have a great rest of your day on Tuesday, and I will see you tomorrow. Bye.